right. Oh. Good afternoon and good morning to our West Coast listeners. My name is Juan Thomas, and welcome to our weekly Chair Chat on behalf of the ABA Civil Rights and Social Justice section. I'd like to welcome all of you this afternoon and this morning, and I want to welcome our guest today, Ramya Krishnan, who is the Knight First Amendment Institute staff attorney at Columbia's Law School and a lecturer in law. Please welcome Ramya to our conversation. Hello.
Hi, thanks for having me.
Glad to have you. You are our guest today because you are working on a very important case that is pending before the Supreme Court, possibly. And we want to talk about the case with you and get your perspective on these important issues. So tell us about Arkansas Times versus Waldrip.
Sure. So Arkansas Times is a First Amendment challenge to Arkansas's anti-BDS boycott law. There are dozens of these laws around the country. And what they say, in effect, is that to do business with the state, you must pledge in writing not to boycott the state of Israel. So these laws affect all sorts of individuals and businesses, from substitute teachers to construction workers. The plaintiff in this case, Arkansas Times, is a newspaper. So before the law went into effect, Arkansas Times routinely published ads for the state-run University of Arkansas. That was actually a significant source of revenue for the paper. But after the law went into effect, the university insisted that the newspaper pledge not to boycott the state of Israel as a condition of getting ad dollars from the university. The newspaper CEO said no. He thought that if he would have signed that pledge, he would be signing away his freedom of conscience. He didn't think it was right that the state was requiring him to take a political position in exchange for a business contract. And so his paper was denied further contracts as a result, which is when the ACLU stepped in and sued on his behalf. Last year, the case reached the Eighth Circuit. The Eighth Circuit held in a terrible decision that the law did not violate the First Amendment. It reached that conclusion based on a misreading of the Supreme Court's landmark civil rights ruling in NAACP versus Claiborne Hardware. So as many of your listeners and viewers, I should say, I'm sure are aware, Claiborne involved an NAACP-sponsored boycott of white-owned businesses in Port Gibson, Mississippi. And the boycott was launched by Black residents after city and county leaders repeatedly resisted calls for racial equality and integration. The businesses sued in response. They sued the NAACP itself, as well as hundreds of boycotters seeking to call back their economic losses. And they were initially successful, but the Supreme Court intervened and it ultimately reversed. And in its landmark decision, it held that the businesses couldn't recover their losses resulting from the boycotters' peaceful activities because these activities were protected by the First Amendment, and that included the boycott itself. The Eighth Circuit's decision closes its eyes to that clear holding. It says Claiborne Hardware held only that the First Amendment protects advocacy of political boycotts, so encouraging people to join a boycott, but not the boycott itself. It says that boycotts are just economic conduct. I think that's a very flawed interpretation of the decision, and it hollows out the central achievement of that case. But thankfully, the ACLU has filed a petition for cert with the Supreme Court. It argues that the decision is wrong. We at the Knight Institute have filed a brief on behalf of several prominent First Amendment scholars in support of their petition. And that petition is now pending before the court. I understand that it's being distributed for conference. Actually, so tomorrow, I think the justices will be considering whether to take the case. And I really hope they do.
So this is a First Amendment free speech issue, in essence. If this is upheld by the Supreme Court, if they take cert and hear the case, what are the implications on free speech? And are there other circuits that are hearing not necessarily this case, but similar cases where there might be a different ruling from a different circuit?
Right. So, this case is a really important one because at stake is our right to engage in political boycotts as a form of collective action. Political boycotts by consumers have been so important in the nation's history, from the Boston Tea Party to the Civil Rights Movement to the campaign for divestment from apartheid South Africa. They've played this enormously important role in political discourse and in our democracy. We've used them to put pressure on powerful actors in an effort to get those actors to change their behavior. The Eighth Circuit's decision eviscerates that right. It says that these political boycotts are not protected by the First Amendment. And what that means is that states have free rein to restrict these boycotts. They can demand that state contractors, promise not to engage in political boycotts as a condition of getting a contract from the state. They can also outlaw the boycotts outright. And what that means is that states have this really powerful tool to kneecap political movements they disagree with. And that isn't just the BDS movement. That could mean the climate justice movement. It could mean the gun control movement. In terms of your second question about, other circuits, as of now, no other circuit has yet being able to consider this question, but every federal district court to consider it has held that these laws violate the First Amendment. The reason why some other circuits haven't yet considered the question is that so many state laws were initially written to reach sole proprietors, and many of the initial lawsuits that were brought on behalf of these sole proprietors. And so what the states did after these plaintiffs won their cases in district court was they changed their law to exclude them so that the appeals were mooted out. So that's why no other circuit has yet considered the question. But we don't think that's a reason why the Supreme Court shouldn't take the case now, because this is such an important question. And many states are already using these anti-BDS laws as a template for going after other movements they don't like. So we really need the court to take the case now and make clear that this activity is protected by the First Amendment and that states can't restrict it just because they disagree with its message.
Right. While you want the Supreme Court to take the case, I'm just thinking a follow-up to your answer. Are you concerned that the Supreme Court might uphold the Eighth Circuit's ruling?
I mean, I sincerely hope that the court.
And I'm asking that in the context of the current makeup of the court.
Right. Yeah, and I mean, I think it's unclear what the court will do. I hope, based on well-established precedent, I mean, and NAACP versus Claiborne is this really important ruling and precedent on the books. Unfortunately, the court has showed a willingness to discard precedents it doesn't agree with in recent years, most notably in Dobbs. But there are many reasons why even the conservative justices may not want to take that step here. Most significantly, consumer boycotts have been employed by people of all political stripes. They're used by the anti-abortion movement. They're used by the pro-choice movement. They're used by the gun control movement, but they're also used by the gun rights movement. And so this is a tool that's used by conservative movements just as much as progressive ones. And I hope that is a reason why even the conservative justices might think that it's important to uphold this right. I think also, some of the conservative justices have at least historically identified as economic libertarians. And so you would think that they would be really skeptical of efforts that interfere with Americans' consumers' right to decide when and what to purchase.
Right.
So I think that there are reasons to be hopeful here, though you can never take anything for granted with this court.
I think we've learned that over the last few years.
Yeah.
One thing I wanted to share with you is that the theme of this year for our section is economic justice. And we're working on a variety of ways. We have an upcoming summit in Washington on this very topic. I'm wondering if you could kind of connect the boycott movement to the struggle for economic justice more broadly.
Yeah, I mean, I think that historically, one reason why boycotts have been so important is that there have been, vast swathes of society that have been disenfranchised, for so long, like well before, Black people had the right to vote in this country, or women had the right to vote in this country. They were able to use boycotts as a tool of mass political protest.
Right.
And one reason why boycotts are so powerful is that, while an individual's purchasing decision might not matter so much in the grand scheme of things, it's a way for people to combine their voices when, otherwise their voices, individually might be lost or ignored. So I think it's absolutely connected to, economic justice and groups using economic power as a tool for creating social and political change.
Yes, you are so right, and particularly in the context you mentioned the civil rights movement during this month of Black History Month. I'm reminded of the Montgomery boycott that was led by Dr. King and inspired by Rosa Parks and others. Fred Gray, who is a longtime civil rights attorney in Alabama and friend of the ABA and many other organizations. That protest movement came out of boycotts and standing up for civil rights and social justice. And a quote that Dr. King often would refer to is that protest is the voice of the unheard. Right. That's how people who are not heard at seats of the tables of power and influence often get heard or become heard. So I appreciate you sharing that perspective. What are your thoughts of how lawyers, and particularly the ABA and perhaps even our section, civil rights and social justice, can play a role in this effort to bring attention to these issues, and particularly to bring attention to this particular Supreme Court or potentially Supreme Court case?
Yeah, well, I mean, I think it's important to note that these laws are part of a growing trend of outright state censorship, whether you're talking about anti-BDS boycott laws or anti-CRT laws or Florida's Don't Say Gay law. I mean, the list could go on and on.
Right.
It's important to put them in context and realize that this is a really dangerous trend with far-reaching implications for free speech. And I think that, the ABA, all of us as lawyers have a responsibility to push back on this, whether it's talking to our friends and family, contacting our elected officials, or donating our time and working pro bono with the civil rights groups that are on the front lines, bringing these legal challenges. It's important to take, whatever steps we can.
Right. From time to time, the ABA has offered amicus briefs in cases based upon ABA policy. And so I think one thing that we should do in the ABA is to determine if we have policy on the specific issue. And if not, perhaps draft that policy. We just left New Orleans with our mid-year meeting. Our upcoming meeting will be in Denver. The next time that the ABA House of Delegates will vote on a series of different resolutions. So one thing I'd like to work with you on is to make sure that the ABA is on the right side of this issue and go through our own internal process to that end. So I offer that to you as well on behalf of our section.
That sounds wonderful. I would love to work on that with you.
Great. Anything else you want us to know about this issue? We know it's being considered for the Supreme Court tomorrow, with whether or not they'll take cert or not. But beyond that, anything else you want us to know?
I think just, to reiterate that, while we're talking about a case that is about, BDS boycotts, this is now seen as a very anti-boycott laws in general are seen as a very successful strategy, especially by those on the right, a model for going after any boycott they don't like, whether that's a boycott of Israel or, fossil fuel companies or gun manufacturers or big ag. And in fact, several states, including, Texas, have already passed boycott laws in all of these contexts. So if the court doesn't intervene now, states are going to be emboldened to pass more and more of these laws, which would be really, really bad. So we need to be watching the space.
Critically important. Are there resources that you would point us to read or to reference that you could share with us as lawyers to learn more about this particular case, or just the anti-boycott movement altogether?
Definitely. So there, an outlet that has done amazing coverage on this topic, I think, is Jewish Currents. So they have a number of pieces on this topic and on this case in particular. Sure. It's worth looking there. The Knight Institute has a case page for the brief that we filed on behalf of scholars in this case, and that includes all of the case filings. So if you search for the Knight Institute's Arkansas Times page, you'll find all of the relevant filings there, and that's a good sort of place to start to get up to speed on the case.
Well, we'll definitely make sure we put that in our social media spaces, and when people watch this video, hopefully they will Google those reference points. On a much lighter note, I wanted to end by asking you more about yourself personally. What is the last book you've read, or what book are you reading currently?
So I just finished a big one. I finished Middlemarch by George Eliot, which was quite the tome. It was a really wonderful book. It was deeply immersive and just very slow burn, which was like a nice antidote, I think, to like the news cycle and Twitter. It was just nice to stay with characters for such a long period of time.
That's important. That's good.
Yeah.
Good. And what do you normally do for fun when you're not putting together Supreme Court briefs?
Which is obviously a lot of fun. Yeah. Nothing beats hanging out with my my 2-year-old pup Ella. She is hyperactive and in constant need of attention, is just always wanting to play, and I feel like spending time with her forces me to be present. So I love spending time with her. Well,
good. And if you could wake up tomorrow morning and be anything except a lawyer, what would you be?
So when I was younger, I spent many years studying opera singing. And so I fantasized
about... demonstrate?
No demonstration. It's been a long while since I actually practiced intensely, but so maybe an opera singer or a bookstore owner. I love books. I love the smell of them. I love selecting them for people I love and for myself. So maybe that is another option as well.
Well, we have two things in common in that regard. I love a good book also. I do listen to books, but I'd rather read a book than listen to one. And I love music. I would wake up and be a jazz musician. So I used to play the trumpet in high school, but that was a lifetime ago.
Yeah.
I want to thank you for being our guest today. I want to thank you for bringing attention to this issue of anti-boycott laws. This is important work, and we look forward to working with you in the future. And thank you for being our guest today. And thank you all for listening.
Thank you. Thank you so much for having me. Juan, it was great to meet you. It's great to have this chat. And